She broke my gate for the fourth time on a Tuesday morning in March, and this time she didn't even slow down to look at the damage. I watched her taillights disappear down my ranch road in a cloud of dust, the splintered gate post lying across my driveway like something that had been in a war. 4 times, 4 broken gates, 4 conversations where she told me with a straight face that the road through my property was a community right-of-way because it was faster than the county road. I stood there that morning looking at the wreckage of gate number 4, and I made a decision that had nothing to do with anger and everything to do with math. I called my attorney that afternoon. By the time the dust settled on what came next, Diane Westbrook owed me $80,000, and she never drove through my gate again. Here's exactly how that happened. My name is Russ Donovan. I'm 58 years old, and I run a working cattle ranch on 310 acres in the Texas Hill Country. This is not a hobby property. This is not a weekend place. This is a real operating ranch that has been in my family for 3 generations, going back to my grandfather, who bought the original parcel in 1958 and ran it as a cattle operation until he passed it to my father, who ran it until he passed it to me about 20 years ago. We run roughly 200 head of cattle, rotating through pasture sections, and we also do some hay production on the flatter ground near the creek. It's real work, every day, regardless of whether I feel like it. Cattle don't care about your schedule. They need water, they need to be moved between pastures, they need to be checked for health issues, and in calving season, the work essentially never stops. The ranch has one main entrance off the county road, a cattle gate set into a fence line that runs the full perimeter of the property. This gate is not decorative. It is functional infrastructure that keeps my cattle contained and keeps unauthorized traffic out. Behind that gate is a ranch road, gravel and packed dirt, about 1.5 miles long, that runs through several pasture sections before reaching the main ranch house, barns, and working corrals. About 8 years ago, a residential development went in on the property adjacent to mine, Stonebridge Hills, a community of about 90 homes built on land that had previously been a different ranch operation that the owning family sold off when the older generation retired. The development's main access road connects to the county highway, about 2 miles south of my gate, but here's the thing that started all of this. There is a more direct route from the back section of Stonebridge Hills to the county highway that cuts straight across a corner of my property, through my ranch gate, and out the other side. Using my ranch road as a shortcut saves a Stonebridge Hills resident driving from that back section of the development approximately 12 minutes compared to using the development's actual designated access road. 12 minutes, that's what this entire situation was about in the most basic terms. 12 minutes that Diane Westbrook decided she was entitled to take from my private working ranch, my cattle operation, and ultimately my patience. Diane moved into Stonebridge Hills about 6 years ago, into one of the larger homes in the back section, the section closest to my property line, which is relevant because it's exactly the section where my ranch road shortcut would save the most time. She was in her early 50s when she moved in, married to a man named Robert who worked in oil and gas and traveled frequently, which meant Diane handled most of the household logistics and was the one regularly driving kids to school, to activities, running errands. She became involved in the Stonebridge Hills HOA fairly quickly after moving in and was elected to the board within her first year, eventually becoming HOA president about 2 years before this story really gets going. By most accounts from people I've talked to who lived in that community, she was an energetic and capable president in terms of the actual administrative functions of the role, budgets, maintenance schedules, communication with residents. The problem was a specific belief she held, one that I think genuinely surprised me with its persistence. She believed that because my ranch road shortcut was convenient for Stonebridge Hills residents, and because, in her words, everybody does it, that this somehow created an actual right for residents to use it. I want to be clear about the facts here because they matter enormously to what happened. My property is fenced. My gate has a sign on it that says private property, no trespassing in letters large enough to read from a moving vehicle. There has never been any easement, agreement, deed restriction, or legal arrangement of any kind granting Stonebridge Hills or its residents any right to cross my land. The development's own legal documents, which I eventually reviewed in detail, designate the development's actual access road as the sole and exclusive ingress and egress for the community. My property is not mentioned anywhere in those documents because it has nothing to do with that development. But somewhere in the early days of Stonebridge Hills, before I was paying close attention, somebody apparently discovered that my gate, if left unlocked or if you simply drove through it, provided a faster route. Word spread informally among residents. By the time Diane Westbrook moved in, the shortcut was apparently something of an open secret in the back section of the development. The first times, before I knew who was doing it. I want to walk through the history of this because it built over time, and I think the build-up matters for understanding why I eventually did what I did. The first time I noticed unauthorized vehicle traffic on my ranch road was about 5 years ago, roughly a year after I started noticing tire tracks on a stretch of road that didn't get much use from my own operation, since it's a connector section between two pasture areas rather than a main route I traveled often. I initially assumed it might be hunters or someone using the road for some innocent purpose, got lost, that kind of thing. I put up additional signage. I checked my gate latch mechanism to make sure it was functioning properly. The tire tracks continued sporadically over the following months. Then about 4 years ago, I caught someone in the act for the first time. I was moving cattle in the section near my main gate and saw a car, didn't recognize it at the time, drive up to my closed gate, stop, get out, open the gate manually, drive through, and then not bother to close it behind them. I was too far away to get a good look at the driver or the license plate that first time, but the open gate was a real problem. Cattle gates exist specifically to keep livestock contained, and a gate left open is a serious operational hazard. I had to spend the better part of an hour making sure none of my herd had wandered through it before I could close it and get back to my actual work. This happened a handful more times over the following year, never frequently, maybe once every 6 to 8 weeks, but consistently enough that I started keeping a log. I am, by nature, a record keeper. Ranch operations require it. You track cattle health, breeding records, pasture rotation, equipment maintenance. Adding unauthorized gate incidents to my tracking habits was a natural extension. About 3 years ago, I finally got a clear look at the vehicle and driver during one incident, a silver SUV, and a woman I didn't recognize at the wheel. I noted the description in my log, along with the date and approximate time. The pattern continued. I started recognizing the SUV. I started recognizing the woman. I did not yet know her name was Diane Westbrook. I would learn that soon enough. The first direct confrontation. The first time I actually spoke to Diane directly was about 2.5 years ago. I had set up a trail camera near the gate after the unauthorized traffic became frequent enough to be a genuine pattern, not for legal purposes initially, just because I wanted better documentation of what was happening and when. The camera confirmed what I'd started to suspect. The silver SUV was a repeat visitor, crossing through my gate at fairly predictable times, generally weekday mornings around 7:15 and weekday afternoons around 3:30, which lined up exactly with school drop-off and pickup times for a school located in the direction this shortcut led toward. I waited for her one Tuesday morning, parked my truck near the gate, and when the silver SUV approached, I stepped out and flagged her down before she could open the gate. She rolled down her window, looking mildly annoyed at the delay rather than embarrassed or concerned, which told me a lot right from that first interaction. I introduced myself and explained that this was my private ranch road, that the gate was clearly marked private property, and that she needed to stop using it. She introduced herself as Diane Westbrook, HOA president of Stonebridge Hills, and said that residents had been using this route for years and that she understood it to be a community access point. I told her there was no such designation, that the property was entirely private, fully fenced, and that her use of it constituted trespassing. She said she found that hard to believe given how long the practice had apparently been going on, and suggested that perhaps there was some kind of historical understanding or informal agreement between my property and the development that predated her arrival. I told her there was no such agreement, that I personally had never authorized anyone to cross my land, and that whatever informal pattern had developed was entirely without my knowledge or consent until recently. She said she would look into it and thanked me for the conversation. She drove through my gate again 4 days later. The gates start breaking. What changed about 2 years ago was the gate itself. Up until that point, the unauthorized traffic had been a nuisance and a livestock management hazard, but the gate itself had typically been opened and closed, sometimes left open, which was bad enough, but the physical structure was intact. That changed when I installed a new gate with an automatic closing mechanism, a heavier-duty cattle gate with a spring-loaded closure system designed to swing shut on its own after a vehicle passed through, specifically to address the problem of people leaving it open. This was a reasonable, proportionate response to an ongoing nuisance, and it solved the open gate problem for most of the unauthorized users, who I assume simply stopped using the shortcut once they had to deal with operating a heavier mechanized gate rather than a simple latch. Diane Westbrook did not stop. What she apparently started doing, based on the trail camera footage I reviewed afterward, was simply driving through the gate without stopping to open it properly, pushing through the closing mechanism with her vehicle, treating the gate itself as an obstacle to be forced rather than a barrier to be respected. This broke the gate, badly. The first time it happened, the spring mechanism was bent beyond repair and the gate frame itself was cracked. Repair cost just under $800 including parts and the labor of the contractor I hired to fix it properly, since gate fabrication isn't something I do myself with the kind of precision a working cattle gate requires. I repaired the gate. Within 6 weeks, it happened again. Same pattern, based on the trail camera timestamp and the silver SUV clearly visible in the footage. Diane had driven through the closing gate rather than stopping for it. Second repair, another $750. I want to emphasize something here. I did not have absolute certainty in those first 2 incidents that it was deliberate rather than simply careless or distracted driving. People make mistakes. I gave her, internally, something close to the benefit of the doubt, even though I'd already had the direct conversation with her about the trespass itself. The third incident removed any doubt. The third gate-breaking incident happened about 14 months ago. I had upgraded the gate again after the second incident, reinforced the frame, added additional signage directly on the gate itself in large red lettering, and most importantly, installed a second trail camera with a wider angle specifically to capture vehicle approach speed and behavior, not just identification. What that camera captured during the third incident was unambiguous. Diane's SUV approached the closed gate at a speed that, based on the footage timing across known distance markers I'd set up specifically for this purpose, was not a speed consistent with someone planning to slow down and stop. She drove through the closing gate mechanism at what my contractor later estimated, based on the damage pattern, was likely 20 to 25 miles per hour. Not a crawl, not an accident of misjudged timing, but a deliberate push through a barrier she knew was there. This third incident caused more significant damage, not just the gate mechanism, but actual structural damage to the gate post itself, which had to be reset in concrete. Total repair cost, just over $2,000. This was the incident that made me call my attorney for the first time, a property and agricultural law specialist named Calvin Reese, who'd handled some boundary and easement matters for my family's ranch over the years, and who understood Texas rural property law thoroughly. I described the situation to Calvin in detail, the trespass pattern, the 3 gate-breaking incidents, the direct conversation I'd had with Diane where she was informed clearly that the property was private, and that she had no right to cross it. Calvin listened and then asked me a question that turned out to be the most important question in this entire story. He said, "Russ, have you ever sent her anything in writing?" I said no. Everything had been verbal, plus my own private documentation through the trail camera logs. Calvin said, "Okay, here's what we're going to do. We're going to make sure the next interaction creates a clear legal record, because what you're describing isn't just trespassing anymore. It's becoming something with real financial teeth if we handle it correctly." The formal notice. Calvin drafted a formal cease and desist letter that he sent to Diane Westbrook by certified mail, with a copy also sent to the Stonebridge Hills HOA board, since Diane's position as HOA president meant her conduct had organizational implications even though the trespass itself was a personal act, not an official HOA action. That distinction would matter enormously later. The letter was comprehensive. It documented the pattern of trespass using dates from my log going back to when I'd first identified her vehicle. It documented the 3 gate-breaking incidents with specific dates and repair costs, totaling just over $3,400 in property damage. It cited the relevant Texas trespass and property damage statutes. It formally demanded that she cease all unauthorized entry onto the property immediately, and it put her on explicit written notice that any further incidents would result in legal actions seeking damages, including consideration of exemplary damages given the demonstrated pattern of willful conduct. Calvin was very deliberate about that phrase, willful conduct, and about the exemplary damages reference. He explained to me that under Texas law, when someone causes property damage through conduct that is not merely negligent but demonstrates a conscious disregard for the rights of others, particularly after being given clear notice, the door opens to damages well beyond simple repair costs. Exemplary damages, sometimes called punitive damages in other jurisdictions, exist specifically to address situations where compensatory damages alone don't adequately address a defendant's conduct. He said, "Russ, I want this letter to do 2 things. I want it to give her every reasonable opportunity to stop, and I want it to create an absolutely bulletproof record that she had clear, written, certified notice if she doesn't." The letter was sent on a Thursday. Diane signed for it. The following Monday, certified mail requires a signature, which meant we had documented proof she'd received and presumably read the formal notice. She drove through my gate again 9 days later. The 4th incident, the one that changed everything. The 4th gate-breaking incident, the one I described at the very beginning of this story, happened on a Tuesday morning in March, exactly 9 days after Diane had signed for the certified cease and desist letter. My trail cameras captured everything: the approach speed, consistent with the previous deliberate incidents, the impact with the gate mechanism, the visible damage. And critically, this time, because the gate's reinforced frame held together better than the previous version despite serious damage to the closure mechanism, the cameras also captured Diane's vehicle pausing briefly after impact, clearly visible for several seconds, before continuing through and driving away without stopping to assess or report the damage. She knew, the footage made it unmistakable, that she knew the gate had been damaged and chose to drive away anyway. I drove out to the gate that morning after a neighbor called to tell me cattle were approaching the open damaged gate, the closure mechanism destroyed, the post cracked again, debris across the road. I spent the first hour just making sure none of my herd had gotten through before I could secure the area with temporary fencing. Then I went home, pulled the trail camera footage, and called Calvin Reese. I described what had happened, the 4th incident, occurring just 9 days after the certified cease and desist letter, with footage clearly showing willful disregard for the damage caused. Calvin was quiet for a moment. Then he said, "Russ, I think we have a very strong case for exemplary damages now. I want to bring in someone who specializes in this specific area to make sure we maximize what we can recover and make absolutely certain this stops permanently. Are you ready to take this seriously? I told him I was as ready as I'd ever been about anything in my life. Bringing in additional expertise. Calvin recommended bringing in a colleague of his, an attorney named Marisa Quintana, who specialized in agricultural property litigation and had handled several cases involving willful property damage and trespass in rural Texas settings. Calvin explained that while he was fully capable of handling straightforward property matters, a case seeking significant exemplary damages benefited from someone with specific litigation experience in maximizing and successfully arguing those claims. I met with Marisa the following week. She reviewed everything, the trail camera footage from all 4 incidents, my detailed log going back 5 years, the certified cease and desist letter and proof of delivery, the repair invoices, and most importantly, the footage from the 4th incident showing Diane's vehicle pausing after the impact before driving away. Marisa's assessment was direct. She said the case had several elements working strongly in my favor. First, this was not a single incident, but a documented pattern over years. Second, I had given clear verbal notice early in the pattern. Third, and this was the element she said mattered most, I had given formal, certified, written notice, specifically warning of legal consequences, including exemplary damages, and the 4th incident had occurred shortly after that notice was received and acknowledged via signature. She said, "Russ, this is about as clean a case for exemplary damages as I've seen in this type of matter." She had every opportunity to stop. She had explicit written warning of the consequences. She did it again anyway, and the footage shows she knew it happened and left without accountability. That's not an accident. That's a pattern of willful disregard. She explained the damages we would be seeking. Compensatory damages would cover all 4 repair incidents, totaling approximately $5,200 at that point. But the real exposure, she said, was in the exemplary damages claim, which under Texas law could be calculated based on a multiplier of compensatory damages in cases of demonstrated malice or willful conduct, subject to statutory caps, plus separate consideration of the trespass itself as an ongoing pattern affecting the operation of a working agricultural business. Meaning, we could also pursue damages related to the operational disruption, the livestock risk exposure, and the cost of the additional security measures I'd had to implement. I asked her what kind of number we might be looking at if everything went our way. She said she didn't like to promise outcomes before litigation, but based on similar cases she'd handled, a combined damages award in the range of $70,000 to $90,000 was realistic given the pattern, the willfulness, and the clear documentary record. I sat with that number for a long moment. Filing suit. Marisa and Calvin worked together to prepare the filing. It took about 6 weeks to put together a complete, airtight case, gathering every piece of documentation, having the trail camera footage properly authenticated and prepared for potential court presentation, getting formal repair estimates and invoices organized, and drafting the complaint itself. The lawsuit was filed in County District Court against Diane Westbrook personally. It was important, Marisa explained, that this be filed against Diane as an individual rather than against the HOA, because the trespass and property damage were her personal actions, undertaken in her personal vehicle, completely separate from any official HOA function. This distinction mattered both legally, since the HOA itself had no liability for actions Diane took outside any official capacity, and practically, since it meant the financial exposure would fall entirely on Diane rather than potentially being absorbed or defended by an organization with its own insurance and legal resources. The complaint sought compensatory damages for the 4 repair incidents, exemplary damages based on the documented pattern of willful conduct following formal written notice, and additional damages related to operational disruption to my cattle operation, including the cost of temporary fencing, the labor time spent securing livestock during each incident, and the cost of the trail camera security system I'd had to install specifically because of her conduct. Diane was served with the lawsuit at her home about 10 days after filing. I did not witness this directly, but Calvin received confirmation of service from the process server he'd hired. What happened next, over the following several months, was a legal process that I want to walk through carefully because I think the details matter for anyone who finds themselves in a similar situation. End of part 1. Diane retained an attorney almost immediately, a litigator from a firm in the nearest city, a man named Patrick Volkov, who specialized in defending civil claims. His initial response to the complaint, filed about 3 weeks after service, took the position that the road through my property had, in his words, developed into a customary route through long-standing use, and suggested that some form of prescriptive easement argument might apply. Essentially, the legal theory that sufficiently long, open, and continuous use of a path across someone's property, without the owner's permission, but also without active prevention, can in some circumstances create a legal right to continue that use. Calvin and Marissa both immediately recognized this argument and weren't worried about it. Marissa explained to me that prescriptive easement claims require specific elements that simply weren't present in this case. Most critically, the use needs to be truly open, continuous, and crucially, adverse to the owner's interests without active objection over the required statutory period, which in Texas is 10 years for this type of claim. Diane had only been using the route for roughly 5 years at most. I had directly confronted her about it. I had sent certified written notice demanding she stop. The use had been actively contested by me from a point well before any 10-year period could have run. Marissa told me, "This argument isn't going to work, but it tells us something important. They're trying to find any theory at all to avoid the willfulness finding because they know what that exposes her to." The court set an initial hearing date about 10 weeks out. In the meantime, something happened that none of us had fully anticipated, something involving the Stonebridge Hills HOA itself, which had been sent a copy of the original cease and desist letter and which, it turned out, had its own significant concerns about what its president had been doing. I got a call from Calvin on a Thursday evening. He said, "Russ, you need to hear this. The HOA board just reached out to us. They want to talk." Part 2. What the HOA wanted. The call that came through Calvin's office was from the Stonebridge Hills HOA's own retained counsel, a measured and careful attorney named Sheila Brennan, requesting a conversation about the situation involving Diane Westbrook. What emerged from that conversation, and from subsequent ones over the following 2 weeks, was that the HOA board, separate from Diane, separate from her individual legal defense, had become seriously concerned about their own exposure in this matter and about Diane's conduct as it reflected on the organization. Sheila Brennan explained that the board had reviewed the original cease and desist letter I'd sent, which had been copied to the HOA, and had subsequently done its own internal investigation into how widely known and how long-standing the shortcut practice had been within the community. What they found troubled them considerably. It turned out that Diane, in her capacity as HOA president, had on at least 2 occasions during community meetings made informal references to the ranch shortcut in ways that some board members felt amounted to tacit organizational endorsement of the practice. Not formal policy, nothing in writing, but comments along the lines of acknowledging that some people use the back route without actively discouraging it or clarifying that it constituted trespassing on private property. This created a genuine concern for the HOA's own legal exposure, separate from Diane's personal liability. If it could be shown that the HOA, through its president's conduct in an official capacity, had encouraged or tacitly endorsed trespass onto adjacent property, the organization itself could face liability, not just Diane personally. The board, upon understanding this risk, moved quickly. They held an emergency meeting. I learned about this afterward through Roy-equivalent channels, meaning informal accounts from a couple of Stonebridge Hills residents who'd heard about the situation and reached out to me directly, somewhat sympathetically, once the broader story became known in the community. At that emergency meeting, the board voted to formally and publicly disavow any organizational position regarding the Ranch Road shortcut, to issue a community-wide communication explicitly informing all residents that crossing my property was trespassing and strictly prohibited, and significantly, to place Diane on administrative leave from her HOA presidency pending review of her conduct, specifically citing concerns about whether her personal actions had created legal exposure for the organization she led. Sheila Brennan's purpose in reaching out to my legal team was, in essence, to make clear that the HOA wanted no part of defending or being associated with Diane's individual conduct, and to ask whether there was anything the HOA could do to demonstrate its good faith separation from the matter, partly out of genuine concern for doing the right thing, and partly, I have no doubt, out of a desire to protect the organization from being pulled into litigation it had no actual legal obligation to be part of. I told Calvin and Marissa I had no interest in pursuing anything against the HOA itself. My issue had only ever been with Diane's individual conduct. They communicated that position back to Sheila Brennan, which I think was received with some relief. Diane's isolation. What I want to convey about this period of the story is how completely Diane Westbrook's support structure collapsed once the actual facts became clear to the people around her. The HOA's public communication to Stonebridge Hills residents, explicitly stating that the ranch road was private property and that crossing it constituted trespassing, landed in every resident's inbox about 3 weeks before the scheduled hearing date. I'm told it generated considerable conversation within the community, much of it apparently focused on surprise that Diane, as HOA president, had been personally engaged in conduct the HOA was now formally condemning. Her administrative leave from the HOA presidency, which had initially been framed somewhat delicately, became increasingly difficult to keep quiet as residents began connecting the timing of her absence from board meetings to the broader situation. By the time of the scheduled hearing, it was, by most accounts, fairly widely known within Stonebridge Hills what had actually happened. I want to be fair here and note that I don't know the full internal dynamics of Diane's marriage or her relationship with her husband Robert during this period, and I'm not going to speculate beyond what was directly relevant to the legal matter. What I do know, because it became part of the public record during the proceedings, is that Robert Westbrook was not named in the lawsuit. The vehicle, while used by Diane for these trips, was registered solely in her name, and the conduct at issue was entirely her own independent action, not a joint household decision in any legally relevant sense. The settlement, NEGOTIATONS. About 6 weeks before the scheduled hearing date, Patrick Volkov, Diane's attorney, reached out to Calvin and Marissa to discuss potential settlement. This is fairly standard in civil litigation. Both sides often prefer to resolve a matter before incurring the full costs and uncertainties of trial, provided a fair resolution can be reached. Marissa explained to me that settlement discussions don't indicate weakness on either side necessarily. They're simply a practical reality of how most civil cases actually conclude. The initial settlement offer from Diane's side was, frankly, insulting in its inadequacy, an offer to cover the documented compensatory damages of roughly $5,200, with no acknowledgement of exemplary damages and no formal admission regarding the willfulness of the conduct. Marissa rejected this immediately and communicated back, through Calvin, that given the strength of our documented case, particularly the trail camera footage from the fourth incident clearly showing Diane's vehicle pausing after the certified notice violating impact before driving away, we were not interested in a settlement that didn't reflect the actual exposure she faced if this went to trial. The negotiations continued over the following weeks. Marissa was skilled and patient throughout this process. She explained to me that her approach was to make clear, through the strength of our evidence and the specificity of our damages calculation, that going to trial was a significantly worse outcome for Diane than reaching a fair settlement, without ever appearing desperate to avoid trial ourselves, since our case was strong enough that trial was a perfectly acceptable outcome from our perspective. This is, I learned, the core skill of effective settlement negotiation. Genuinely being prepared and willing to go to trial gives you the leverage to negotiate a better settlement, because the other side has to seriously weigh the real risk of a worse outcome at trial against whatever you're asking for in settlement. The settlement that was ultimately reached after approximately 5 weeks of negotiation totaled $78,500. This included full compensatory damages for all 4 gate-breaking incidents and the operational disruption costs. It included a substantial exemplary damages component reflecting the documented willful pattern of conduct following formal written notice. It included full reimbursement of my legal fees through the date of settlement, which Marissa had structured as part of the negotiated terms specifically because the strength of our case made that a reasonable ask. And it included a formal, binding agreement, not just a verbal understanding, but a legally enforceable consent order, that Diane would never again enter my property under any circumstances, with specific and substantial liquidated damages provisions if she violated that agreement in the future. Marissa called me the day the settlement was finalized. She said, "Russ, I want you to understand what just happened here. This wasn't luck. This was 5 years of you keeping good records, the moment you got proper legal advice and sent that certified letter, and the fact that she chose to drive through that gate again 9 days after signing for it. Every piece of that mattered." I asked her what made the final number land where it did rather than somewhere significantly lower. She said the trail camera footage of the 4th incident was the single most decisive piece of evidence, not just that the gate was broken again, but that Diane's vehicle visibly paused after the impact, clearly aware that significant damage had occurred, and then drove away without stopping to address it or even acknowledge it. She said that single piece of footage, more than anything else in the case, transformed this from a property damage dispute into a clear demonstration of willful, knowing disregard, exactly the kind of conduct that exemplary damages exist to address. I thought about that for a long time afterward. 4 broken gates, 1 certified letter, 1 camera angle that happened to catch a few extra seconds of footage. That's what an $80,000 outcome actually came down to in the end. What $80,000 actually meant. I want to talk about what that settlement money meant for the ranch, because I think it's easy to focus on the number itself without understanding the actual impact. The ranch, like most working agricultural operations, runs on tight margins most years. Cattle prices fluctuate. Hay yields depend on rainfall we can't control. Equipment breaks down at the worst possible times. A settlement of this size, after legal fees were accounted for, which Marissa had successfully built into the settlement itself rather than coming out of my pocket, represented genuine, meaningful capital that I was able to put toward things the ranch actually needed. I used a portion of it to fully overhaul the ranch's perimeter fencing system, not just the section near the disputed gate, but a broader upgrade I'd been putting off for several years due to cost. I installed a more comprehensive security camera system covering multiple access points, not because I expected another Diane Westbrook situation, but because the experience had taught me the value of clear documentation, and I wanted that capability built into the ranch's infrastructure going forward rather than improvised in response to a problem. I also used a portion of the settlement to finally replace an agging tractor that had been needing replacement for about 3 years, which improved our hay production efficiency meaningfully the following season. What the money represented, beyond its practical uses, was a kind of vindication that mattered to me in a way that's hard to fully articulate. This ranch has been in my family for 3 generations. My grandfather built this operation from nothing. My father expanded it and kept it running through some genuinely difficult agricultural years in the 80s when a lot of similar operations failed. I have spent 20 years making sure it continues into a 4th generation, since my own son has expressed real interest in eventually taking it over. Someone deciding repeatedly that her 12-minute convenience mattered more than the integrity of that operation, more than my fences, more than my cattle's safety, more than basic respect for clearly marked private property, was something I was never going to simply accept as the cost of having neighbors nearby. The settlement wasn't really about the money in the end. It was about making absolutely clear, in terms that couldn't be misunderstood or dismissed, that this ranch's boundaries mean something. Diane's situation afterward. I learned, through the same informal channels within Stonebridge Hills that had kept me loosely updated throughout this process, what happened to Diane in the aftermath. She did not return to the HOA presidency. The administrative leave the board had imposed during the litigation became permanent. She formally resigned the position about a month after the settlement was finalized, citing a desire to focus on personal matters, which I think most people in the community understood to be a face-saving way of describing what had actually happened. I'm told the settlement amount, while not publicly disclosed in any official way, became generally known within the community fairly quickly. These things tend to circulate in close-knit residential developments regardless of confidentiality intentions, and I have no specific knowledge of how that happened, only that it apparently did. The Westbrooks remained in their home in Stonebridge Hills. I have no direct knowledge of how the financial impact of the settlement affected their household, and I'm not interested in speculating about it. What I do know, because the consent order required ongoing compliance and my new camera system would have caught any violation immediately, is that Diane never approached my gate again. Not once, in the time since the settlement was finalized. The gate today. The gate itself has been rebuilt, actually rebuilt 3 times now, since I made the most recent and most substantial upgrade using settlement funds, installing a heavier commercial-grade system with reinforced posts set in significantly more concrete than the original installation, along with the comprehensive camera coverage I mentioned. It has not been damaged since. Stonebridge Hills residents, following the HOA's formal community-wide communication clarifying that the road is private property and crossing it constitutes trespassing, appear to have stopped using the shortcut entirely. I check the camera footage periodically, partly out of habit at this point, and partly because vigilance is simply part of how I operate the ranch now, and the road sees exactly the traffic it should see. My own vehicles, my own equipment, moving cattle between pastures, the way this road was always meant to be used. My son Caleb, who's 26 now and increasingly taking on real responsibility for the ranch's daily operations, as I think about what the next phase of this family's stewardship of this land looks like, asked me once what the whole situation had actually taught me, beyond the obvious lessons about documentation and legal process. I thought about it for a while before answering him. I told him that the lesson wasn't really about Diane Westbrook specifically. It was about understanding that the things you build and maintain and protect, whether that's a cattle operation 3 generations in the making or just a gate that keeps your animals safely contained, those things only stay protected if you're willing to actually protect them. Not aggressively, not angrily, but methodically and persistently, with the patience to document things properly and the willingness to follow through when someone repeatedly disregards a boundary you've made clear. 4 broken gates taught Diane Westbrook a lesson about property rights that cost her $78,500 and her position in her own community. 1 rebuilt gate, standing solid against a Texas hill country sky, is teaching the next generation of this ranch family something quieter, but just as important, that what's yours is worth defending carefully and correctly for as long as it takes.